under IP protection.
Screen and deliver her talk. Madam, please.
Good afternoon, everyone. So today's presentation is on IPR registration and details of how to register. So, as Professor Dept Dev has highlighted, we are all. Am I audible to everyone? If somebody can.
Yeah, madam, can you please speak a little louder? Like it is audible, but the volume is less.
So, is it okay now?
Yeah, it's okay, madam. We'll let you know if there's any problem.
Okay. So, as Professor has highlighted the importance of IPR in the coming generation, and as with the current pandemic situation, COVID, so IPR is utmost important, and this patent is very highlighted very much as the recent TRIPS agreement, as we have seen. So today I will show you the website where we can file online copyright, trademark, patent, everything. But now let's start from the very beginning. As Sir has already highlighted all things, but once again I will throw some light to this. So what are the different types of IPRs? That's copyright, trademark, geographical indication, design, patent, trade secrets, semiconductor, plant varieties. So patent, if we go, so patent is an exclusive right, it's a monopoly right from excluding others from using, selling, offering for sale, making somebody's innovation. So and the patent is granted to a person whose innovation is new, non-obvious, and having some industrial application, some social utility, and this can be applicable in some arenas, some aspects. So a patent is valid for 20 years from the date of filing. It is a priority date, and it has to be renewed after that if some modifications are done, or otherwise it's come in public. So now let's look. So what can be patented? So see how patent origin. This is the idea. This first we start searching. That is the research R&D work. This is the starting of the innovation. So searching R&D work, this idea is written, and some analysis has been done. Some designing is done, prototyping. Then we go for patenting. Then initial patenting, we go for fund generation, presentation, some financing. Then after that, we go for licensing, then product manufacturing, branding. Then we can sell the product and then earn the value in the market, the money. So these are the patenting process, as we have seen, a new, non-obvious, capable of industrial application. So patent is not granted if something is found already existing in public domain. So if, for example, there is some research work already published or some thesis already there, so the applicant has to defend himself that how his innovation is novel from the already existing innovation. So that is the thing. And now non-patentable invention. So what is non-patentable? That is a method. So there are some of the non-patentable invention or things, that is treatment of human and animal. So the process of treatment, therapy, all these are not patent. Invention causing serious prejudice to human, animal, plant life. For example, during the World War I, the Galiton, which was invented in France, used for killing people, such type of invention cannot be patented. Computer program per se algorithm. Computer programs come under copyright. So mere discovery of a new form of a known substance. For example, the substance is already in the presence of a salt or a compound. Some new form of existing of that substance is found. So it is not patentable. Mere and mixtures as aggregation of the properties. For example, you connect a fan and
Excuse me, madam.
umbrella together.
Excuse me, madam. Hello, madam.
Yes.
Your screen is not in full screen mode.
Okay.
Your slides are not in full screen.
Is it visible? Is it okay now?
It is visible but not in full screen mode.
Not in full screen mode. Sir, I have done it full screen. Can you check it now once? Is it visible?
It is visible, not in full screen mode. It's all right, madam. It is visible. It is visible to us. It's all right.
Is it in full screen mode now?
No, not full screen. But you can see your writings in the slides.
Uh, One second. So what I will do? Shall I stop and present once again?
Yeah, you can try it once again.
One second. Uh, I am stopping the sharing and I am share once again. Okay.
Yeah.
So is it visible in full screen mode now?
No, ma'am, it's still not visible. It's all right, madam. It is. You can easily view your entire writing from the slides.
One second. What is the error? Is it visible now full screen mode?
No, it is not visible. I mean, it happens sometimes. It's all right, madam. You can continue. No issue.
Huh?
You
So
can
is
continue,
it
madam.
visible full screen mode now?
Yeah, madam. It is visible to us. No worry.
So shall I continue?
Yes, yes, madam. Perfect.
Okay. So now let's go for observing some of the non-patentable things. So presentation of absurd type. For example, already existing natural laws and traditional knowledge. These are some different way of protection. This cannot be protected by patenting. So and we have to take another type of sets of procedure is there. Presentation of abstract ideas, the natural laws, for example, Newton laws, mathematical business method of agriculture, invention which falls under atomic energy. So these are the non-patentable things. Now, so some patented inventions, this sir has also shown, these are the very common. So idli making machine, this is also a patented invention. Sir has explained about this thing. So I need not to explain once again. So following persons who are entitled to apply for patent, that is the true and first inventor of the invention. Any person being the assignee of the person claiming to be the true and first inventor and a legal representative of a diseased person. So, and they can file procedure of filing patent. There are sets of fields and sets of forms. For example, Form 1, Form 2, Form 3, and Form 5. So, these are the and these are the forms. So, Form 1 is the application form. Form 2 is the provisional complete specification. If we want to get our priority date beforehand, before the completion of the full prototype, we can go for provisional. Then after some improvement, we can get complete specification and file the complete form. Then Form 3 is undertaking, statement and undertaking. Form 5 is declaration of invention. Form 18 is request for examination. Form 28 is for academic institutions. And
Ma'am, your slide is not changing.
has it changed? My slide has changed.
No, it is not changing. You are in the slide like non-patentable invention. Yeah, now it has changed. Yeah,
Has it changed?
yeah, it has changed.
Okay.
Yeah,
Okay.
ma'am, please be little louder. Actually,
Uh,
voice is little
Am I audible now? Actually,
audible, but
I would request everyone to increase the volume because they can increase their volume. Uh,
uh, yeah, I have increased mine. Actually.
uh, all the participants they can increase their volume, and I think slide is it okay? Is it okay
Yeah,
with the
slide is
slide?
okay. Yeah, yeah, this slide is
Okay,
okay.
okay. So the patenting process, that is, we start with filing and provisional patent application. Then within 12 months, or we file a complete specification with all the modifications, drawings and claims. So only difference between filing a provisional specification, complete specification is that it doesn't have a claim because we are not, we doesn't know what we are claiming when you are filing a petition. But when you file the complete specification, we are making our sets of claim and our protection, our invention or innovation will be protected on the basis of the sets of claims we are making. And the drawing, the full inventions, representation, flow charts, diagrams we are providing. So at the end of the presentation, I will show you the forms also that how it looks like. So withdrawal of application can be done within 15 months and the form get automatically published after 18 months if a request for early publication has not been made in form number 9. So if for MSME startup they want an expedited patent application, so they can make request for early publications and early request for examination. So request for examination within 48 months from priority, from date of priority, and after that, after the examination report is communicated to the patentee or the assignee or the legal representative, the patent attorney. So reply for the report has to be made within 6 months, which at max can be extended by 3 months. That is the reply to FER. First examination report has to be made within 6 months, and at max it can be extended by 3 months. So controller hearing. After that, the controller hearing is done. If some opposition is there or hearing from the parties, and then the final grant of patent is there. So this is the flow chart. You can see the filing of patent application with provisional specification. Then within 12 months, we go for complete specification. After that, there is a publication in 18 months, that is in the patent journal, patent office journal. And from here, we wait for pre-grant opposition. And post to that, there is a request for examination which has to be made from any parties. For example, suppose somebody has opposition, he can also file the opposition along with the request for examination, and the original owner or the innovator can himself file, and he has to himself file an examination in form number 18. So after examination, patentability is assessed, and hereafter FER, that is the first examination report, is issued, and the reply to that has to be made within 3 to 6 months. And the reply failing to reply to FER, the application gets abandoned. But once the objection are made and the reply has been done, the patent is granted and it is published in the official patent journal gazette. So let's see the fees. The application for grant of patent, that is for a natural person and for an educational institution, 1600. And regarding other, the provisional complete specification statement undertaking under section 8, then the declaration, this all doesn't need any fee. There's a request for early publication, there is fee of 2500. Request for examination of application for patent, that is 4000. Patent filing, physical filing. If we go for hard copy physical filing, then the application fee is 1750. That is 10% more than the what is the fee, plus the examination fee 4400 and the professional charges. So an overview of the aforesaid form, as I've already explained, the form 1 is very important. The name, address of the inventor, all the other details like applicant address, then area of business, information corresponding to prior patenting and authorized entity, some other declarations. So form 2 is having the 30 suite forms, and if we are filing the provisional application, then the claims is not there. Form 3 is the statement and undertaking regarding any foreign filing or any PCT route is taken or not. And form 5 is declaration as to inventors. Declare that the invention, the subject matter is short to, and the person is the true and the first inventor of the invention. So now the form 9 is request for publication. If the MSME startups, they want early publication of the form. Form 18 is the request for examination of application for patent. Within 48 months from priority date, the form 18, then request for examination has to be made. So the request, it has to be made in the 4 patent offices, like any of New Delhi, Mumbai, Chennai, Kolkata, any of the offices it can be of. Now let's just proceed to trade. So the trademarks, the word itself signifies a lot. It's trade and marks. The two things together make trademarks. So concept, symbol, brands, and logo, it's everything. So it's like this. The trademark is a symbol of origin, a source of mark that bear the stamp of quality. For example, we buy Dettol soap. How do you recognize? With this trademark, Pizza Hut, McD. So these are the symbols. Function of trademark, it's provide identity, source, quality, advertising. For example, we buy the milk of Amul, but because of the quality of the Amul. Suppose the cheese of Amul, just because of the quality, just looking at the trademark, the word name Amul itself is the trademark. So go for a trademark which is easy to speak and tell, that is appealing and easy to remember, and having maybe a monogram, logo, geometrical device, representation. So don't go for a trademark which consists of the laudatory words like best, perfect, super, etc., or geographical names, common surnames, matter prohibited under the law, a matter which is similar or same to already existing trademarks in the market. The types of trademarks, conventional marks, that is a word mark, as I have shown, for example, Amul, Nike, Armani, Adidas. These are the word marks, the representation of the word in any way, it doesn't matter. The word Amul itself is a trademark, Nike, Armani, Adidas, the representation doesn't matter, but the word is a trademark. Service mark, this representation for the trademark is recognized for the type of service they provide. Collective mark, for example, chartered accountancy, company secretary. So all these type, this is the mark for organization. Certification mark is for egg mark, ISI, wool mark, for FSI, like this is a certification mark. The certification marks signifies the certification, quality, purity of the product and originality of the products. So unconventional mark, for example, the representation color mark having a distinctive color. For example, purple color package for Cadbury. Shape mark, the shape of the product represents the good. And smell mark, for example, the bubble gum having a specific smell. Sign mark like and the sound mark like the hearing, like the yardle of the Yahoo. When you go to Yahoo, there's a significant sound. So that is a trademark. So trademark registration process is very fast because we have to encourage our MSME, our startups with this domestic process. Within 12 months, it get granted, and the filing starts from form trademark application form A, and then immediately examination of the application happens. Then publication in trademark journal and the trademark registration approved. So now just look at the detail, like the receipt of application data entry digitization at the branch office, maybe let's say in Mumbai office, then ERS number is issued. Then in case of objection, uh, the objections, there is a hearing, and in case of no objection, the examination report is conveyed to both the parties, and it is published in the official journal. So in case of no objection, and the trademark certificate is issued to the person, the entity. So trademark fee 5,000 plus professional charge. Trademark registry, that is also again we have to go IP India office, that is under DPIIT. So I will show the office after we complete the presentation. Then let's see copyright. So copyright itself shows the thing copy and another is the right. That means there are many things come under this: author, content, way, property, guidelines, laws. So what are the things covered under copies? As sir has highlighted many things earlier. Again, if I see the repetition, like the literary includes software, books, essay, compilation, dramatic, screenplay, drama, sound recording, artistic work, musical, cinematography. So literary work, it is lifetime of the author plus 60 years after the death of the author. Anonymous, pseudonymous work, it is 60 years from the date of publication. Sound recording is 60 years from the date of publication. Cinematographic work is 60 years from the date of first publication. The term of copyright, as I have explained, so how can you contribute? We should not purchase anything, we should not get any pirated movies, photo, text, illustration. We should get everything from authentic source. This signifies that we respect others' work, others' property. So we have to be creative and innovative ourselves for writing a thesis. We have to, if we are taking anything from others, we have to give a reference to that. We have to give the link, the reference, and we have to mention that we have taken such and such reference to such and such journal. Then only it is a authentic thing. So registration process. Registration we have to apply in form 14, that is the statements of particular and further statements, and for each separate work we have to file a separate form and separate sets of these applications. So this signed by applicant and accompanied by requisite fee to be paid to the registrar of copyright. So if we look at the detailing, the filing of application along with fees, that will be a DD or online IPO, issue of diary number, then 30 days mandatory waiting period for any objections. If objection is there, then sending letter to both the parties, reply from both the parties, what is the objection, then there is a hearing by the registrar himself, then the application based on the objection overruled or not, it is accepted or rejected. And if there is no objections, uh, it is it directly goes for scrutiny by examiner. The scrutiny looks for any discrepancy based on the earlier work, or is it a copy of some other work, or what type of forms of expression, because the copyright, the forms of expression gets protected. It is not it is the forms of expression which so we find the discrepancy in the previous work, and based on that a discrepancy letter is issued, then the applicant has to rule out all the discrepancy. There will be a hearing by the registrar, and based on it the application will be granted, accepted, or either rejected. If the registration approved, the sending extracts from the registrar to the applicant, and now the registration certificate is issued. So the copyright, if we go, registration fee 500 for literary, dramatic, musical work, and 2000 for sound recording, 5000 for cinematographic film. So this is the copyright website. This is the copyright.gov.in under DPIIT. You can directly proceed here and file your own application with the sets of forms and prerequisite fee, or an attorney on or an agent on your behalf can do if you are not much confident of this. But copyright office is located in Delhi, and it is under the DPIIT. Design, if we look what is the design, you can see this forms, this pattern on the surface, which makes gives some aesthetic value to this object. It's just for beautification, it's just it doesn't have any functional aspects. So this is the design. The shape, you can see the shape over here, shape, arrangement, line, color combination, ornamental, which gives a ornamental value to it. And the design right is protected for 10 years, which can be extended max up to 5 years. So design should be eye-catching, original, applicable to any article by an industrial pro- and applicable to any article by an industrial process, and should not be a functional aspect, should not be an artistic nature like painting, sculpture, etc. It's just a form of pattern of expression. That's it. So as you can see the form, the beautification on this bottle, this beautification on this cover or everything. So this bottle, this for which increases its value, aesthetic value in the market, but it is not having any functional aspects. So this is the design. So how, what can be registered as design? As I've already explained, the things can have to be new, original, non-disclosed to public, distinctive, and not against public order or morality, and not functional in nature. So what cannot be registered as design? Book cover, calendar, certificates, metal, greeting card, postcard, documents, forms. This all these are covered under copyright. This is the design, the pattern, or the forms of expression is not covered under design, or the design inside an almirah with some interior design, because it is not displayed on the surface. Anything which is displayed on the surface, which gives a beautification, aesthetic value to it, increases its marketability in turn, and the exclusive right has been provided for this. So how can you contribute? Again, we should not copy others' design. Yes, we can make a, we can learn from that. We can make a better version of the already existing products, already existing rights. We can enhance ourselves, but we cannot copy the same and represent that and tell that it's ours. So it's against design. So it's against any of the IP rules. So registration of design, file application form 1, design wing in Kolkata branch office. So it is transferred to the design classification of design. So it is looked at the classification of design. Then the examination is proceeded. Then the notice of objections, if any found, then within 6 months the defects has to be corrected and it has to be resubmitted. Then after resubmissions, the patent office journal, the design office journal goes through it and be published, and then issue a design certificate after approval of the designs. So if we look at the detailed process, the filing of application, numbering, formal checking, examination of the application, look for any objections already existing or compliance, then give a notice for the objection, there is a hearing, then there is a if compliance of the objection is there, then within 6 months of filing, acceptance is there, and the publication in patent office journal. So this process is also very fast because it has very huge industrial application, and mostly the design MSME, the MSME startups, they file for design trademark. So the to enhance our economy and for some economic benefits. So the process is fast and enhanced. So this is also the same thing. So design right, design fees, that is application fee of 1,000 rupees plus professional charges, and for organization 4,000 plus professional charges. So that is individual and organization. So design registry, this is also under IPM. So now let's come to geographical indication. So the name itself indicate that something related to the geography of the area, climate of the area, the speciality of the area. So now just look at what is geographical indication. GI is a sign of product. For example, this product is due to the climate, the temperature, the humidity, the specific soil type found in the area, and the specific skill set of the artisans, of the local producers, which are not present in anywhere else apart from that area. And if we look for Assam, the geographical indication of Assam, the Muga silk of Assam, I think. Yes, we have lots of we have Muga silk of Assam. Then Assam tea is there. Then another Assam ginger is there. Karbi Anglong ginger, Joha rice of Assam. Okay, so Judima of Assam, that is a beverage drink. So okay, so my screen is visible to everyone.
Yes, ma'am. It is visible. It is visible.
Okay. So geographical indication. So some of the apart from Assam, if you look, Mysore silk, Rajasthani Kathuris, Naga mirchis. So northeast we are having lots of geographical indication, and we need to improve the livelihood of the local artisans, craftsmen, and in the way we have to recognize them, provide a recognition to already existing. So I will come to the flow chart that how to identify and how to get them registered. So it is an indication, and in outside country, only agricultural products are given geographical indication. But in India, we are giving geographical products. Like for example, apart from agriculture, natural and manufactured goods are also given geographical protections. For example, definite territory of India, anything which is manufactured also gets a geographical indication. And some example, that is Darjeeling tea, Kachipuram silk, Alfonso mango, Nagpur orange, Kolhapur chappal, Bikaneri bhujia. So these are some of the geographical indications. As we can see, a blue pottery of Jaipur, Chanderi fabric of Madhya Pradesh, Kutch embroidery Gujarat, Solapur Chaddar Maharashtra, Mysore silk of Karnataka, Anamula Kannadi, that is a metal mirror of Kerala, Kanchipuram silk of Tamil Nadu, Salem fabrics Tamil Nadu, Pochapalam Akati of Andhra Pradesh, then Bastar Dokra, that is a silver or brass toy of Chhattisgarh, Orissa Ikka, that is the fabric sari of Orissa, Madhubani painting Bihar, Kulu shawl Himachal Pradesh, Kanish shawl Jammu and Kashmir. So these are some of the Judima of Assam, and initially before the beginning I have told there are some 8 to 10 GIs of Assam, so I have already mentioned. So how can we contribute? So we have to facilitate protection of collective rights of rural and indigenous artisans. And we have to see that some outside company or some outside intruder doesn't copy their right or doesn't make some conflicting product which is related to them or selling in their name. We have to recognize the user organizations or anything, or we can get this rights registered in turn to make a good livelihood. As we know, India is a rich storehouse of geographical indication. Here every 10 kilometers the climate changes, we go so look at, we are having this subtropical region, tropical region. We are having all the types of climate which a country can have for prospering and making a wide variety. As such, we are a unity in diversity ourselves. We from Kashmir to Kanyakumari, there is lots of diversity, but still we are united. So this is the speciality of Indians. So we can protect, we have to respect each other cultures, each other rights, and we have to protect them. So we have to recognize them. So this is the way. Who can do this? A research entity, NGO, public authorities, other economic activities. So producer, they may not be aware, but some 500, 600 producers are producing the same product in a area. So they are processing, distributing, in turn going to consumer. So there can be an inspection body, that is a public authority, who inspect and in turn provide a report to them, and they can earn an accreditation from the national regulator, from the GI office. So in turn the norms of the GIs are applicable. So if we look here for the detailed process, filing an application, examination, we wait for objection, opportunity for hearing is there, then accepted, advertised in GI journal, then another opposition if any, and then another, if it is finally accepted, entered into GI registry and certification is granted. There's two parts, part A and part B. So GI indication registry, it is governed under the Geographical Indication of Good Registration Protection Act 1999, and it is the head office is in Chennai. So another, if you see the detailed process, I have already explained. It is here. Once again, the step of filing I have explained in detail. So the starting from step one, step two, we have explained. So now just let look at a file, geographical indication. So this is a journal copy of a final publication which has been done after acceptance. It is an Iticopa toys of Andhra Pradesh. So Andhra Pradesh Handicraft Development Corporation Limited is the applicant in behalf of the artisans who are making this Iticopa toys. This has been made from a special plant, that is Bigitia tinctoria, uh, and the toys, they are making a variety of product apart from toys. For example, they are making kumkum boxes, bangles, and jewelry from this type of thing, necklaces, beads. So this using this particular wood. So the Etikopa is the name of the village in Andhra Pradesh, and the toys, all type of representation, the items, handicraft things they are making, got the name from here. So these are the address. This is the address type of goods. It is under class 20, that is handicraft. There is a class is there, nice classification, which is having some 50 around classification. Though this is under class 20, having toys, games, utilitarian product, gift, decorative item, jewelry, images of gods. So these are the things they are making with this particular type of wood, which has speciality in itself due to this geography. So you can see the geographical area production and map. So there is an representation that what type of climate, in what is the latitude, then proof of origin, history has been given, method of production, raw material used, and dyes used, everything. So this is the thing. This is the way the final journal copy of geographical indication looks. So now let's move to semiconductor integrated layout design. Semiconductor integrated circuit layout design. It is covered under Semiconductor Integrated Circuit Layout Design Act 2000. So it deals with the way of representation of the semiconductor. These are having a transistor and other circuitry elements. So layout design and other circuitry element include lead or wire in it. So they should be original, distinctive, and their representation, their layout should be unique from already existing layout. So should not have been earlier exploited. It should be a unique. So should be capable of distinguish from another's layout design. So let's go to trade secret. So what is trade secret? As I have seen, Sir has already highlighted this and enlightened upon this. So once again, I would throw some light to it. So including R&D information, these are some software, algorithm, invention, design, formula, which is very crucial for the company to run, for the business to run. For example, let's take a example of KFC recipe. It is very different from the another recipes, Domino's recipe, or the Pizza Hut, the unique combination of masalas, they doesn't disclose it. The KFC is not disclosing its specific recipe for the chicken. So that is the thing. So it is a method of doing business, or the consumer profile, or some very crucial information. If it is disclosed, it is going to cause some economic losses to the uh, producer. Now let's see upon this plant variety. So plant variety, it is also now the upcoming IP right, because we have seen at grassroots level the farmers are producing very organically without any much fertilizers or anything other. They are producing very noble variety of plant which is distinct, noble, uniform, stable in its variety, but they are not having the recognition. So these plant variety farmers protection Act 2001 is providing uh, rights to this farmer variety, and we will see the website of plant varieties in few seconds after I complete my presentation. So genetic resources, traditional knowledge. Genetic resources, this is again a very wide arena where the traditional knowledge holders are having a huge knowledge, and they are exploited by pharma companies. We can know the very well-known case of basmati rice and turmeric, which are applied for patent application in USA, and CSIR fought for that and they own the case. So, because we are having this knowledge already in our Ayurveda, it is quoted. So, and for any research which we want to do in our traditional knowledge or the plant variety, so we have to take biological diversity. Act 2000, you have to take permission from NBA, National Biodiversity Board, that is in Chennai, or National Biodiversity Authority. They will give grant permission, then only further research can be carried out on traditional knowledge. And the agreement of the confirmation of the thing is that we are going to share the benefit with the actual knowledge holder. The fruit of the research, the fruit of the technology licensing will be transferred with the original knowledge holder, because they may not be aware of their rights. So to make us more aware, CSIR has created traditional knowledge digital life. So this has been set up in 2001 by CSIR in collaboration with Ministry of Ayush, and this is having some 3 lakh entries of traditional medical system of Ayurveda, Unani, Siddha, Yoga. This website also is we are going to see in next 5 minutes, because and this is having translation in 5 languages: English, Japanese, French, Spanish, and the several international searching authorities, they are also having an access to this, because they should not patent or apply for patent for their traditional, for the already noted traditional knowledge in our Indian traditional medicine system. Encourage the modern research in traditional knowledge and will make us more aware in this. So allow now the end of my presentation. Now I will share the websites. So, this is the we are having total 417 GI registered. If we go, this is the PCT filing which sir was highlighting. Sir has already highlighted, but I will throw some light to this. That invention, then there is an international filing. The international filing, the receiving office is the national office. They, in case, transfer the form to International Searching Authority or International Preliminary Examination Authority, and the International Bureau. Then it is published there. After publication, it is communicated to the national and regional patent office, the receiving office, and then the whole patenting process goes on. So thus it is a single window publication, or in all PCT countries, convention countries, and we doesn't need to apply separately. So this is the timeline for the application. So is my screen visible to everyone?
Yes, yes, madam. It is
Okay,
visible.
so this is the single gateway of IP India. This is the single gateway e-filing of patent, then payment of fees, WIPO, PCT filing, e-filing for trademark, e-filing for design, e-filing for geographical indication. So when you go over here, this is the patent comprehensive e-filing services. Then go, this is the search for the patent. If you want to search something, or suppose if I am clicking over here, e-filing of patent, it is taking me to some external site. This is the e-filing application. We have to create as new user. Once you create an ID password over here, the step by step, then we can file our application ourselves. So this is the patent website. It's look like this. When we are searching or looking the status, suppose I have written a word automatic and I search for it, I will get this artificial intelligence based automatic diagnostic system, or another thing. I can, this many inventions are there in the name of automatic. I click over here. If I click, I get this application. So it is filed and published. So if I want to view the documents, I can view the document. So what are the things published, like complete specification, declaration of inventorship, drawings, educational institution, they can get a fee waiver for that, evidence for registration, figures of abstract, form 1, then form 9 for early publications, power of authority or power of attorney, request for early publication, statement and undertaking. So these are the things. So this is how it's look like. So So this is the Plant Variety and Farmers Authority. This is the website where we want to register, go for registering our plant variety. This is the DUS center, that is sustainable. Our product has to be it has to be sustainable, and the quality should not change with time. For example, the three most basic parameters which are needed for, that is distinctive, uniform, stable. So these are the parameters, and we can file our application, or we can file apply for the farmer's right over here. If you go, so they have given certification to cereals, fiber crop, vegetable, oil seed, legumes, sugar fiber, fruit, spices. So everything is there in this website. You can go and look over here. So these are the list of certificates given. So these are the things. So it's everything is available nowadays online. If we want, we can go and visit everything. So this is the traditional knowledge digital library, TKDL library. You can select the language. We have discussed 5 languages there. So I have selected, if I select English, then I can go and search everything in English. Okay, so these are the things. Now this is the GI state-wise list. Everything is already there. So these are the form 1. How does the form 1 looks like for the patent application? So this is the form 1. This is where this for office use only, and this is where we have to start filling it. This is how it looks, the form 1. Then let's look. So all the credential, all the address, all the, if we have opted for PCT or not, if it is a divisional application, and what are the criteria, everything is there. Now the details under, these are the fees. So everything is there in our patent application.
Madam, madam, it is finished.
Okay, so this is the form 2. It's look like this, whereby you have to file the. Is the screen visible to everyone?
Yes, madam, it is visible.
Okay, okay. So the form 2 looks like this, having provisional complete specifications look like this, and we have to file the details, the claims, the dates, nature, abstract of the inventions, and the description, detailed description with the diagrams. So this is the form 3, which is with the statement and undertaking, which the applicant has to take himself in the presence of the attorney, or he himself can. So these are the things, the undertaking he has to sign, that I am applying for such and such thing. This is the true innovation. Then the request for extension of time, the form 4. This is how form 5 looks like. The form 5 declaration for inventorship, that he is the true and first inventor of this invention. So these are the forms piece. This is the IP India website whereby everything is available over here. Okay. So this is the copyright office. It's look like this. So you can see the copyright. How can you register? We have to set of forms are there for copyright along with the forms and fees. So you have to create a ID, password, everything over here, and then you have to file the copyright. So hmm. So this is the okay. So these are the application form. The application for registration of copyright form 14. Somebody has asked I think about how to register the copyright. So application for change in particular is form 15, and the application form for the relinquishment of copyright form 1, proforma of discrepancy letter that is issued by the examiner. So every proforma is there, every form is there. This is the DPIIT copyright section. So this is the online filing of geographical indication guidelines. Under this is given what are the guidelines, what is the timeline, everything is written. And new user, the person, organizations, because geographical indication is a collective right, is not the individual right. So the organization or the producer organization who want to file it, they have to sign up like new user, and then all the details have to be filled, and then the application gradually all the instruction will be there, and they can apply for the geographical indication, and thereby the examination and grant will be there. So the online design filing, this is IP India website. This is where a design can be filed. Individual can file a design. This is the IP India website whereby the online filing of trademark can be done. This is where you have to create as new user, and you have to see the class where it's fall, and then you have to apply. This is the WIPO PCT filing, and this is the e-filing for patent application. So now I am stopping to share my screen, and if any highlighting is needed, because I think I have finished my time, so I should stop now. So I am stopping the screen sharing, and here over to your again, sir.
Uh, yeah, now thank you, Ms. Gorai, for highlighting the idea of patents, things that can be patented or non-patentable. The process of filing patents